Recognition of gender is a sign of respect in Euro-American societies. So we just need to think about the US series Scrubs. In the series, Dr. Perry Cox really likes to misgender Dr. John Dorian, who's a cis man. Perry Cox really shows his disdain for John Dorian through traditionally feminine pronouns and first names that are also, feminine coded. Far from being, trivial, this practice really shows Dr. Cox as someone who's cruel and who will harass his employees and create a toxic work environment just for the entertainment of the public. Thankfully, it's only a fictional character. However, for non-binary people, misgendering is often the norm. Despite respect, which is really erected to the level of principle in school environments, and despite social advances regarding the right of trans people, respect of pronouns and agreement, gender-neutral agreement, remains a significant barrier for non-binary students. The lack of knowledge of non-gendered grammar and epicene forms, as well as the lack of consensus on the topic among, Quebec trans communities, is only making the problem worse. Although degendered writing has really come to the forefront of public interest in recent years, gender-neutral French remains in early stages of development, and little academic interest and time has been dedicated to it. In English, on the contrary, it's relatively easy to speak in a gender-neutral manner using pronoun they. Few academic works really look at the Franco-Quebecer context, with most Anglophone work forgetting their linguistic specificity, whereas French academic work tends to give very little attention to trans realities. Can we talk of an obligation to respect people's pronouns and agreement in a context where the majority of words are gendered and where no way of speaking has yet to be the object of a community consensus? Are the rights of trans people circumscribed by linguistic ease? What role can and do take institutional politics and guidelines vis-a-vis respect for non-binary people? Those are the kind of questions I'm asking in this article. I'm approaching this topic as a transfeminine francophone person who uses both she and they pronouns in French, but only feminine accordance. So she and they pronoun would be elle and ille, as opposed to other gender-neutral pronouns who also exist in French. So the question of respect for pronouns and neutral agreement is really circumferential to me, but doesn't touch me in all of its complexity because I use feminine agreement. By really foregrounding this ambiguous rapport that I have with my own gender, I really want to underline the impact of experience on the analysis of human rights, which necessarily calls upon our experiential knowledge when comes the time to evaluate the gravity and the proportionality of discriminatory actions. In the first section of the article, I will expound the socio-juridical context that is relevant for the evaluation of respect for gender-neutral French. In the second section, I will try to determine, as of right now, what is the existence and the limits of any juridical obligation to respect gender-neutral French for non-binary people. And in the last section, after having concluded that the legal protections are at best uncertain, I will highlight the importance of institutional policies in order to fill the gaps of the law and ensure the respect of non-binary people. And I will also suggest a number of important additions to recent policies that have come out that concern non-binary people. So let's start with socio-juridical context. In this section, I really draw a portrait of the socio-juridical context that is relevant for the juridical evaluation of the obligation to respect non-binary people, and to elaborate policies that are adapted to those realities. So the portrait really in two parts. The first is what is the consequence of misgendering, and what is the background of psychosocial vulnerability in non-binary people. So not respecting people's pronouns in accordance or agreement is common in educational contexts. It has been one of the primary revendications of trans communities and non-binary communities in recent years. As Alexandre Baril says, it's a way of showing respect, of showing acknowledgement and recognition, and it's very important in the transition process so that people accept themselves, but also feel that others accept them. Not recognizing someone's gender really disturbs their social identity and is felt as a psychological harm. And a higher frequency of misgendering contributes to anxiety and depression, as been shown by studies. So the feeling of stigmatization linked to misgendering does not appear to be any lower for non-binary people than for binary trans people, and non-binary people represent about a third of young trans people. Now, other forms of disrespect or violence are common. 56% of young trans people answering the questionnaire of Galantino et al. Had in the last 6 months seen their reputation attacked. 52% had been victims of insults or other forms of bullying or being made fun of, and 17% had been victims of physical violence. In another study, 87% of young trans people had reported having been victims of verbal harassment in the previous year. Over 46% of young people had missed at least one day of school in the past month because, among other things, of harassment and disrespect towards them. Now, many studies demonstrate that hostility and insensitivity towards gender raises the risk of suicidality and of school dropouts. Over 90% of trans Ontarian students had missed school or avoided school out of fear of being harassed or being read as trans. In my opinion, respect for pronouns and agreement is one of the primary manifestations of social support in everyday life. So it's even more important to respect those things when students who are trans and non-binary are paying particular attention to signs of acceptation and of tolerance in school context. The right to education depends on an atmosphere that feels safe and comfortable, which includes respect for the gender of non-binary students. Unfortunately, the majority of institutions do not have a lot of knowledge on the topic of trans realities and do not have the tools necessary to see that non-binary kids' gender is respected. Although the studies by Chamberlain, Baril, and Duchesne are not specifically about the knowledge of gender-neutral French, the complexity and novelty of it allows us to think that the knowledge would even be worse on that level. The disrespect of non-binary people is common, but it's no less devastating. If respect for gender-neutral French comes a little too late, can law help and even create an obligation for their systematic respect? That's the question that I'm now turning to. In the analysis, in the analysis section, I will analyze the breadth of the law regarding respect for pronouns and agreement from the perspective of the right to privacy, the prohibition against harassment, and the right to equality. And I will conclude that those protections are limited and have an uncertain scope, especially regarding agreement. So trans people are protected by the Quebec Charter of Human Rights and Freedoms. Before gender identity and expression were added to the Charter through Bill 103, the protection of non-binary people was a little bit uncertain, although trans people were protected under the notion of sex since a 1998 decision. My friend and colleague, Maître Jean-Sébastien Sauvé, has noted that it's not clear that all trans people were protected under this decision and following decisions, because non-binary people don't fit as easily into the binary conception of sex as it is used in Quebec law. Since gender identity and gender expression were added, the 10th article of the Charter reads something like, everyone has a right to recognition and to the exercise in full equality of the human rights and freedom without distinction, exclusion, or preference based on gender identity or gender expression, independently of any legislative intent, which does not seem to be directed specifically toward non-binary people. This change does have the effect of explicitly including non-binary people within the scope of the protections of the Charter. The protection of the state having been granted to non-binary people, their juridical status is from now on less uncertain, although formal protections do not always lead to substantive protection. Now, the obligation to respect gender-neutral French and to respect the pronouns and accordance of non-binary people can be understood through three lenses: privacy rights, harassment, and the right to equality, or the right against discrimination. So the right to privacy does offer protection regarding the disclosure of the gender assigned at birth of a non-binary person, although this protection does not have a lot of efficacy when the assigned gender at birth is known to others, or when the misgendering does not reveal it. So it's not really an effective protection for pronouns and agreement. So both the Quebec Charter and the Civil Code of Quebec recognize the right to respect of one's private life, but the non-binary private sphere can be understood primarily in terms of the confidentiality of the gender assigned at birth, and the confidentiality of the dead name, which is name that was attributed at birth, and confidentiality regarding anatomy. Confidentiality in law is what we usually think about the right to anonymity. So something that discloses an information such as the gender assigned at birth of someone would really breach this right to anonymity. The distribution of information relative to one's state of health or one's anatomy, as well as sexual orientation and things like as transitude, so the state of being trans, are all included in the right to anonymity. However, pronouns and gender-neutral accordance already disclose transitude insofar as a non-binary person is not cisgender. They are of a gender that's different than the one they were assigned at birth. So as from a general standpoint, the right to anonymity will not protect someone who is non-binary from their status as a trans person being disclosed, although it is brought into relief when a person is misgendered. Misgendering can, however, reveal the gender assignment at birth, as well as primary and secondary sexual characteristics, which opens the door to harassment from other students. The right to privacy remains fairly limited. It's difficult to have a legitimate expectation regarding the confidentiality of one's gender assigned at birth if it is generally readable, so if it's visible for the public at large. The right to privacy is also prevented from doing its work when insofar as non-binary people communicate the fact that they're trans, simply by virtue of disclosing their pronouns and accordance. It's not surprising, however, that privacy rights are not well adapted to that, because the hurt caused by misgendering really comes from the invalidation of one's gender. Privacy rights is not about feeling invalidated. So we can already guess that protections against harassment and the right to equality will be better placed to delineate and punish the trans antagonism that's inherent in misgendering. So we turn to the prohibition against harassment. Now, prohibition against harassment is large and seems to reasonably include all intentional disrespect or repetitive disrespect of someone's gender-neutral pronouns and accordance. As we'll see in this section, the fact that misgendering can constitute a form of harassment in itself can lead to a breach of the right to equality. So harassment by virtue of someone's identity or gender identity or gender expression is prohibited by the Quebec Charter. The Article 10.1 tells us that no one can harass someone by reason of one of the motives that is under Article 10, and those motives, those grounds include gender identity and gender expression. So it's really a complementary article that complements the right to equality. Since it's not defined under the Quebec Charter, we can turn to the Ontarian law, the Human Rights Code, for a definition of harassment, which is defined something like the fact for someone to make remarks or vexatory remarks or acts which that person knows or should reasonably know that are to be undesired. That definition illustrates the notion of harassment in Quebec law, although it is not defined under the Charter. Now, it's not necessary for the intention to harass, for an intention to harass to be there, for there to be harassment. It will suffice to demonstrate vexatory conduct or an undesired conduct, which has a frequency and gravity that lead to a durable effect on the person. As the tribunal notes in Gaston, and as the Commission Ontarienne des droits de la personne, so the Ontarian Commission of Human Rights note, it's the point of view of the reasonable non-binary victim that is relevant to determine whether the conduct is harassment, not the perspective of the perpetrator. So, however, in the light of dominant social and linguistic norms, it will be difficult to prove harassment if the perpetrator or the accused was not told or did not take the time to inform themselves about the gender identity and the pronouns and accordance used by the non-binary person. Occasional misgendering will also be excused by the law because of the frequency criterion within the definition of harassment. Given the conception that tribunals have regarding misgendering, it's quite likely that that misgendering can constitute harassment. In previous cases, it was held that describing someone on the basis of their gender assigned at birth is considered to be a violation of their right to dignity. In XY v. Ontario, which led to the recognition that, which led to the availability of birth certificate changes without genital surgery, tribunal had really put a lot of weight on the fact that ID that did not concord with a person's gender was invalidating of the person's identity and suggested that that identity is not sufficiently legitimate. So the same effects are really there when we're talking about misgendering a non-binary person. There's really no significant difference there. So, taking into account how harmful misgendering can be and the hostility and the hostile atmosphere that is created by it, non-respect of gender-neutral pronouns and accordance is seemingly a form of harassment as defined under Quebec law. The right to equality is really a bridge between individual prohibition against harassment and institutional responsibility regarding the respect of non-binary gender identities. Schools and educational establishments can be held legally responsible of the misgendering of its personnel, as well as the misgendering of other students if they do not make sufficient efforts to eradicate their harassment. The responsibility of the establishment can come into play by a refusal from teachers and other staff who are in a position of authority to intervene when a person is misgendered, whether it be by an adult or a student. This aspect of responsibility is really crucial in an educational context because of the degree of inter-student interaction. And this responsibility is articulated through the juridical notion of a toxic workplace environment or toxic environment. The discrimination of the toxic environment is inherent to the environment. So this type of environment is discriminatory and thus falls under Article 10 of Quebec Charter, which is the right to equality. Proving a toxic environment can be done when an institution fails to provide a school environment that is free from harassment. The existence of a toxic environment gives rise to an obligation to intervene on the part of responsible people. Unless there is a later justification, the establishment is responsible for any failure to these obligations, as insofar as the teachers and the members of the staff have to intervene. The role of teachers is particularly important given the obligation to provide an environment free from harassment, because teachers have a more direct access and authority over students. So justification. So human rights are not absolute. A violation of the prohibition against harassment or a violation of the right to equality can be justified by an establishment if no reasonable accommodation is possible. So the reasonable accommodation and the obligation to accommodate is defined as the obligation to take measures of reasonable accommodation in favor of people who are experiencing the the prejudicial effects of a policy or of a rule that is in appearance neutral. And this obligation ceases when it would lead to undue burdens. The goal of this obligation is to recognize the complex ensemble of systemic barriers that are apparently neutral, but who have an important impact on the well-being of students or of other people. Justification of a barrier to equality is done in 3 steps. First, the barrier has to be linked to a legitimate goal. Secondly, it has to be linked to a honest and sincere belief that the barrier is necessary to the satisfaction of this legitimate objective. And thirdly, this barrier must be reasonably necessary to the satisfaction of this objective. It's really the 3rd step that contains the obligation to accommodate up to an undue burden. And it will be and the burden to justify the barrier and to justify the impossibility to accommodate really falls onto the school or the school board. Facilitating social intercourse through sociolinguistic norms that are shared through everyone, and which leads to respect for students' gender is, in all possibility, the objective that justifies the norm under which students and teachers have the role of guessing someone's gender. The objective does seem to be legitimate. We can think that someone had the sincere and honest and good faith belief that it was necessary to have that rule to facilitate social interactions. The fact that it's wrong, that the belief is wrong, is not legally that relevant at this step, insofar as any sincere and good faith belief will suffice. So it's really on the 3rd leg of the analysis that will see the contentious core. Is this barrier reasonably necessary to the satisfaction of the objective? If the answer is no, the barrier is unjustified, and that we're done, and it's discriminatory, and not much more to be said about that. If the answer is yes, we'll have to ask ourselves whether a reasonable accommodation is possible. Gender-neutral language is not well known. It's difficult to use constantly, and many people would be insulted if they were gendered in a neutral way. Many binary trans people would probably be invalidated if people were to use gender refers for them. Whether we share or not these sentiments, the very fact that they exist will have an impact on the evaluation of the necessity of the barrier. So it does appear that, on a kind of general scale, the objective is served by the norm of letting people choose their language on the basis of appearances. Now the question gets harder at the level of accommodation. In an Anglophone context, it's quite difficult to argue that individual accommodation would bear an undue burden. Respecting non-binary people basically just means changing the pronouns he or she by they. So even though habit can take a little bit of time to develop, my experiences show that it's still a relatively easy change. In fact, the campaign No Big Deal that was created by the non-binary professor Lee Ayrton is grounded in this idea that, respecting neutral pronouns in English is easy. It's no big deal. However, French is not English. The singular pronoun they has existed for for hundreds of years. To accommodate someone simply means redeploying the usage of an already well-known pronoun. No such consensus exists in French. Although there's an eminent consensus surrounding the pronoun est-ille, which is the most used, it remains a neologism like other genitive pronoun, and do not actually tell us anything about accordance or about agreement. It's the grammar in its entirety. It's French grammar that has to be revised. I've myself, assisted to and taught, in fact, workshops on neutral genitive French, and I use it quite regularly in reference to people close to me. And I still notice that when I use them orally, it's a little bit slower. So it wouldn't be surprising that some people will try to justify their refusal to accommodate by saying, look, it makes it really hard to use French. It's really heavy on speech. Now, it does seem that, forcing people to use a certain language and making it hard on them would be legally relevant burden, especially since, facilitating school interactions is a legitimate desire and legitimate type of goal which we can impose a burden on. So the question is, well, is it an undue burden? For that, we'll have to take into account the nature, the legitimacy, and the strength of the interest at stake. Now, I believe personally that it's not an undue burden, but my perspective as a trans person is not shared, to my knowledge, by any of our judges, with only one known trans judge in Canada at this point. The existence of an obligation to respect genital pronouns and agreement is ambiguous and really hits up against the uncertainty of law. If respecting merely the pronouns can hardly be judged to be excessive, respect for agreement could be. Without the judgment, with a clear legal scope, what the scope of the right to have one's pronouns and agreements respected is also falls under uncertainty. The details of the accommodation is also going to be important. Some people, for example, use pronouns such as elle, ille, or al, but accept gendered agreements. Other people have set up a sort of flexible hierarchy of agreement and pronouns, giving people who are in good faith having difficulty with gender for French, giving them the choice to gender the agreements in another way, all the while respecting the non-binary student. So this accommodation is less likely to be judged as representing an undue burden than would an accommodation asking for respect for gender-neutral agreements. The obligation to accommodate is not only substantive, but it's also procedural. In fact, it's part of the duty of the school to include the non-binary person in discussions on the accommodations. This procedural obligation is really essential taking into account the variety of choices and linguistic identifications of non-binary people. Someone who uses, neutral pronouns could very much like me desire to be categorized, with women, in at large or during student events, and see themselves in some gender terms like princess. It's also possible to use a gender-neutral pronoun, all the while accepting gendered agreement. In such a case, I think that the obligation to respect pronouns and agreement is quite clear, and that the law really becomes uncertain if neutral agreement is requested. Now we turn to policies and education. When we don't have a clear and certain law, institutional policies can play an important role in promoting respect for the gender of non-binary people. Those policies are much cheaper to establish, can be much clearer, specific, and flexible than the law, and can also codify norms that are more demanding than the minimal legal obligation. Law being uncertain regarding respect for gender-neutral agreement, institutional policies should contain clear and detailed recommendations on this topic. Do we have to respect gender-neutral pronouns and accordance? Yes. Who does? How? Now, many organizations and institutions have established in recent years policies that include respect for the pronouns of trans people. You can think about the Nova Scotia Ministry of Education and of Youth. We can think of the guidelines regarding the support of trans students of the Montreal School Board. You can also think about the mesures d'ouverture de soutien envers les jeunes trans et les jeunes non-binaires of the national table of the fight against homophobia and transphobia in education. A bunch of other documents also bear on the measures that schools should take to support trans youth in both Francophone and Anglophone contexts. So there's a lot of it. Now, as Chamberlain and Puig remark, without explicit measures, students have to rely on staff to accommodate them in using their new identity, and thereby exposing themselves to misunderstanding and to rejection. So it is quite good that the various documents on the topic do include a recognition of the duty to respect pronouns of non-binary students, and do include the duty to make systematic the process of changing gender markers on documents. This duty can even go so far as, the duty to have a third option, or even to, remove all gender markers on the student's file, which is a fairly, important, which is, really going way further than what is going on in most schools at this point. Another step that we could, think about is to systematically include pronouns and desired agreement on student lists, which would help against misgendering. Now, unfortunately, the policies of the Montreal School Board and the National Table are quite strongly inspired from policies that come from Anglophone context, including the Canadian Federation of Teachers, which has a really great 2011 guide. So the fact that they rely on this, as well as the relative absence of non-binary people in the drafting teams of those policies, conspire together to produce a relative lack of attention given to the question of gender-neutral agreement in French. This dynamic, this lack of attention that's given to French, combined with a lack of attention to non-binary identities, really echoes the observations of Alexandre Baril regarding French Francophone feminist studies, with the difference that, you know, here it's binarism that's centered instead of cis identities. So all the while law is dealing with the difficulties of gender-neutral French, our institutional policies are refusing to attack this issue. This refusal perpetuates the lack of protections which non-binary students must face. Like Chamberlain and Puig say, it's by relying on policies, institutional policies and guidelines, and by knowing that the establishment supports them, that staff as well as students can develop smaller scale actions among the establishment. So it's really important to stop and ask what those people are experiencing and what needs they're expressing. Now, those are recommendations that really need to be followed. In a recent study by Taylor et al., only 24% of school boards in Quebec have a policy regarding harassment of trans people. And those policies probably don't include a whole lot of suggestions regarding specifically non-binary youth. Now, we can think that many school boards will follow in the path of the Montreal School Board in the future years and will adopt a policy regarding trans youth. This is great. We're at a critical moment in the propagation of those policies, and that's precisely why it's so important to underline the importance of developing those policies and developing policies regarding the respect for gender-neutral French in agreement in a detailed manner. A list of the most common pronouns must be given. Yel, yel, yel. You know, they all sound the same. They're different. Ael, ael, ael. 3 other ways of writing that one. Ol, 2 ways of writing that one. I, only 1 way of writing that one. Ul, only 1 way. Al, I, im. So those are our most common one. Strategies of gender-neutral agreement must also be given, such as truncated graphy, like with the you know, putting a dot in the middle, neologisms, and other new ways of writing things, like L instead of L and E, and also Abyssin writing, such as élève instead of étudiant or étudiante. You know, this one is written the same way both ways. In developing future policies, we will have to engage more largely trans and non-binary people in the writing process. It's something to be criticized that the national table did not include non-binary people or many trans people in the writing. The content of those policies will have to reflect the diversity of non-binary people, as well as recognize the difficulty of gender-neutral French. There's no general formula to respect every non-binary people. Our policies will have to be sufficiently flexible in how they're written so that action can be undertaken and adjusted based on the individual student. Putting into work respect for non-binary people must take into account the perspectives of Francophone trans people, as well as of people who have learning difficulties and disabilities. Both Anglocentrism of trans language, as well as the difficulties of, as well as learning difficulties, create a rift between the realities of, Anglophone cisgender people and the realities of Francophone trans people. The notion of transcriptee time of Alexandre Baril forces us to think and to act and to realize that we will have to invest concrete resources to teach gender-neutral French to the whole Quebec student body, and not only to students who learn easily. It's not sufficient to say that we have to respect pronouns and agreements of trans people. We also have to define and teach gender-neutral French. So to conclude, in its actual form, the Quebec Charter promises a number of protections to trans and non-binary people. Some of the protections suggest an obligation to respect gender-neutral pronouns and agreement, if they're requested, of course. Unfortunately, the ambiguity of the situation on a juridical, in its juridical aspect, as well as the inaccessibility of tribunals, make this obligation quite difficult to enforce. The gender norms that are unique to French create a juridical asymmetry, as well as a factual one between Francophone and Anglophone contexts, even within a single jurisdiction. So there's a grave need for additional academic research on non-binary people and on gender-neutral French, without clear directives on the part of tribunals, of courts. The current trend toward the creation of institutional policies does show them to be perhaps the most promising recourse to trans students and non-binary students. So it's really essential for activists to highlight the procedural aspect of the obligation to educational establishments, because it really evidences the transformative potential of consultation. Even though its application is difficult and underdone, law can inform and motivates new policies, given the importance of respect for trans and non-binary people and the importance of that respect on their well-being, on their educational success. The recent guidelines of the Montreal School Board are really, despite their imperfection, a turning point in access to education for trans people. Let's hope that other educational establishments and school boards will follow in their path.